The Supreme Court has put a temporary stop on Mandir-Masjid cases across the country, but what if I told you that there's more to the story than just talking about the Places of Worship Act 1991, and that the Ram Janmabhoomi Babri Masjid judgment is going to be back in discussion in the Supreme Court? So of course we know that the Supreme Court is hearing petitions challenging the constitutional validity of the Places of Worship Act 1991. In these petitions, the Supreme Court gave a significant order on Thursday when it ordered courts across the country to not pass any orders on suits disputing the character of existing places of worship. This is an interim order, and this bar on courts hearing or passing these orders on such suits will continue till the next date of hearing, which is in February next year. Now, the order becomes important, of course, because lately there have been several cases pending in the trial courts filed by Hindu parties asserting their right to worship at sites where mosques currently exist. The Supreme Court's order is set to impact and temporarily pause cases involving 11 such sites, including Gyanvapi Complex, Jama Masjid in Sambhal in Uttar Pradesh, the Bhojshala site in Dhar, Madhya Pradesh, and Ajmer Sharif Dargah in Rajasthan. Now, just to let you know, Section 3 of the 1991 law prohibits conversion of a religious place of worship or a section of a religious place of worship into a place of worship of a different religion or a different denomination of the same religion. And violation of Section 3 can lead to a 3-year imprisonment and a fine. Now, court orders on these pending suits directing survey of the religious structures has sparked a row, with critics arguing that such directions violate the 1991 law. This law, as I said, freezes the character of religious places of worship. More specifically, experts have claimed that these orders violate Section 3 of this 1991 law. What was interesting, though, is that one of the judges on the bench, which has now passed this order on Thursday, Justice K.V. Vishwanathan, also said that even if Section 3 of this 1991 Act is not invoked to object to these civil suits being filed, it ought to be objected to on the main constitutional principle that the Ayodhya judgment had spoken about. But what is this constitutional principle that Justice Vishwanathan was talking about that may bar such suits apart from the Places of Worship Act? Essentially, a 5-judge bench of the Supreme Court in the 2019 Ayodhya judgment had said that the 1991 law was designed to protect the secular fabric of the country. It said that the 1991 law reflects the commitment of India to equality of all religions and imposes a positive obligation on the state to preserve the religious character of all places of worship as they stood on the day India attained independence. The Supreme Court had asserted that historical wrongs cannot be put right by people taking the law in their own hands. So the law, that is the Place to Worship Act, was seen as an obligation towards enforcing our commitment to secularism under the Indian Constitution. It was even seen as a law designed to protect the secular features of the Indian polity, which is one of the basic features of the Constitution. The Supreme Court had even said that the court cannot entertain claims that stem from the actions of the Mughal rulers against Hindu places of worship in a court of law today. It said that the law is not the answer for anybody who seeks solace against actions of any number of ancient rulers. Now, referring to the Ayodhya judgment, Justice Vishwanathan observed that civil courts cannot run a race with the Supreme Court when a constitution bench had set out certain principles. And these are the principles that he was talking about that I just told you about. So in other words, the Supreme Court may also look into how these court orders in these civil suits could be challenged on the ground that they violate larger constitutional principles of secularism, irrespective of the Place of Worship Act. And of course, we're going to keep an eye out for the arguments that happen in these petitions as well as any further court orders. So do keep an eye out on the Print's YouTube channel as well as the website. This is Apoorva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.